Hello, I'm Daniel, the Arizona Supreme Court's AI Court News reporter. I'm here to report on an opinion issued by the court today using a script drafted by the justices. A new Arizona Supreme Court ruling clarifies how underinsured motorist coverage applies, or doesn't, when it comes to off-road accidents. In a unanimous decision in the case of State Farm versus Jacey Lee Orlando, the court concluded that insurance companies are not required to cover off-road ATV accidents. Jacey Orlando was seriously injured while riding as a passenger in an ATV in California's Imperial Sand Dunes. The ATV driver's insurance paid up to its limit, but that wasn't enough to cover all of Orlando's damages. She turned to her own insurer, State Farm, under her underinsured motorist policy, but State Farm denied the claim, citing a definition of motor vehicle in the policy that excludes vehicles designed primarily for off-road use, unless the accident happened on a public road. State Farm initially filed a declaratory judgment action in Maricopa County Superior Court, seeking a ruling that coverage did not apply to Orlando's accident. Although the Superior Court agreed with State Farm, the Court of Appeals reversed that decision, stating that Arizona law did not allow for such an exclusion. However, Justice Bill Montgomery, writing for the court, clarified that under state law, underinsured motorist coverage does not apply to vehicles designed for use primarily off public roads unless the accident happens when the vehicle is being driven on a public road. The key takeaway for this ruling means insurers may exclude off-road vehicles like ATVs from such coverage unless the policy specifically states otherwise. For ATV riders and outdoor enthusiasts, this decision underscores the need to know your coverage unless the policy specifically states otherwise. To read the news release, visit azcourts.gov. Thanks for watching and follow us for more updates on important court information.